Okay, so let's get into something pretty significant happening in U.S. employment law. There's been a federal court ruling, maybe more than one, that could really shake up how companies hire.
Yeah, exactly. And what's interesting is we're basing this discussion today on an audio excerpt we came across detailing these recent judicial decisions. So our job really is to unpack what they mean.
Unpack the legal side and, I guess, the real-world implications.
Precisely. For businesses, for job seekers, it seems like a potentially big shift.
Okay, so it's not just like a one-off weird ruling then.
No, apparently not. This is actually the second time in just the last few years that a federal court has said non-citizens, people without legal residency, can actually sue employers over requirements for those statuses.
Wow. Okay. And this latest one?
It came out of South Florida,
Well,
a federal judge there following up on a lawsuit brought by MELDEF.
MELDIF, that's the Mexican American Legal Defense and Educational Fund.
That's the one. Yeah, a very well-known civil rights group. They specialize in discrimination suits. And what connects both of these cases, the Florida one and the earlier one, is MALDEF brought them both.
Okay, so MELDEF is driving this.
And crucially, both cases involved plaintiffs who have DACA status.
Right, Deferred Action for Childhood Arrivals. That Obama-era program gives temporary status work permits to younger people brought here as kids.
Exactly. And that's key to understanding the court's reasoning, it seems.
So tell us about this Florida case. What were the specifics there?
Okay, so this involved a Venezuelan immigrant in Miami, David Rodriguez. He sued Procter & Gamble, the big consumer goods company.
P&G.
Right. He applied for a paid internship, but was denied. And the reason given was basically because he wasn't a legal resident or a U.S. citizen.
Was it explicit? Did they actually say that?
Apparently, yes. P&G's application stated pretty clearly, candidates needed to be a U.S. citizen, a national, a refugee, asylee, or have a green card, basically. Lawful permanent resident.
And Rodriguez wasn't any of those, even with DACA.
Correct. He had DACA, so he was authorized to work, but didn't fit into those specific buckets P&G listed. So MALDEF jumped in and filed a discrimination suit.
Okay, so what did the judge say? How did they rule?
Well, the judge, Kathleen M. Williams, appointed back in 2011, she sided with Rodriguez. And she really relied heavily on that previous MALDEF case from 2014.
The earlier one you mentioned.
Exactly. That one's against Northwestern Mutual. Similar situation. A Mexican national, Ruben Juarez, also DACA recipient, denied a job because the company required a green card.
And what happened there?
The federal judge in New York, in that case, agreed with MALDEF. They said requiring proof of legal residency specifically, like a green card, put an additional burden on DACA folks.
An additional burden? Meaning it was discriminatory?
Yes, unlawfully discriminatory against DACA recipients because they are legally allowed to work, just don't have that specific green card status.
So Judge Williams in Florida basically picked up that precedent.
Pretty much. She said, look, P&G's policy by demanding only those specific statuses, citizen, green card holder, etc.
Right. It could be construed to discriminate against a subset of legal aliens which are protected. Her words.
A subset, meaning work-authorized non-citizens, like DACA holders.
Precisely. She found the P&G case strikingly similar to the Northwestern Mutual one, where that court found the policy impermissibly discriminated against a subclass of lawfully present aliens.
So, okay, the big picture here is these rulings are kind of carving out a new protected group, not just race or gender, but like work-authorized status itself.
That seems to be the direction, yes. It suggests that having legal authorization to work, even without being a citizen or permanent resident, might afford protection against certain types of hiring policies.
So if I'm, say, an HR manager listening to this, what's the immediate red flag? What should you be worried about in your company's application process right now?
The big red flag is any kind of blanket requirement that automatically filters out anyone who isn't a citizen or a green card holder without considering if they are otherwise legally authorized to work.
Like those online systems that just kick you out if you tick the wrong box. Exactly those. Those are now potentially discriminatory under these rulings. Companies probably need to shift from just asking about status citizen, resident, to asking about work authorization.
So the focus shifts to, are you legally authorized to work in the U.S., rather than, are you a citizen or LPR?
That seems to be the safer ground legally, yes. Especially recognizing that DACA holders who are work authorized are increasingly being seen by courts as a group protected from these specific status-based exclusions.
It feels like it's broadening the whole idea of employment discrimination.
It is. It ties into that concept of disparate impact, where a policy might not intend to discriminate, but it ends up disproportionately harming a legally protected group. And here, the courts seem to be saying work-authorized non-citizens, like DACA recipients, can be such a group in this context.
So wrapping this up then, the core message is, companies absolutely need to review those hiring requirements. Just asking for citizenship or a green card might land you in legal trouble, particularly with work-authorized people under DACA.
Definitely. It signals a fundamental change in how employers have to think about eligibility.
Okay, so that really leaves us with a big question, doesn't it?
I think so. For anyone involved in hiring, the question now is, how do you need to adjust your policies in light of these rulings? And maybe even bigger, what does this signal about how we define employment discrimination itself, especially around who's actually eligible to work in the U.S.?